BC's Personal Information Protection Act received Royal Assent on October 23, 2003, and went into force on January 1, 2004, making BC one of only 3 provinces to have provincial private sector privacy legislation. PIPA applies to more than 1 million private sector organizations, including businesses, charities, nonprofits, associations, political parties, and labor unions. Today, BC's Information and Privacy Commissioner Michael McEvoy shares his thoughts on the anniversary of PIPA, how the privacy landscape has transformed since the legislation was passed, and reforms needed to make sure PIPA best serves the needs of British Columbians.
So in the early 2000s, British Columbian legislators, I think, determined that they needed to protect the privacy rights of British Columbians. Certainly there was legislation federally in this country, but its breadth wasn't extensive. In addition to that fact, British Columbians would have to go to a distant place to seek a remedy for any privacy related issues. So it was determined that a made in BC solution that was harmonious and worked together with federal legislation was the sensible approach to take, and that's what they did. It's far more expansive than the federal legislation in terms of the organizations it covers. It also provides the regulator, that is our office, with the ability to make orders, for example, which is not the case federally at the present time, although we hope that'll be reformed shortly. But with all of that in mind, the legislature came together in the early 2000s to pass legislation which became effective in 2004 that has really benefited all BCers. The Personal Information Protection Act has really afforded British Columbians with a framework in which they can be assured that their personal information is being properly handled by organizations. We have received, since the legislation has been in effect, thousands of complaints and concerns raised by individuals about how organizations have done that, how they have or haven't protected their personal information. The nature of those complaints and the nature of our work has very much changed over the last 20 years. I think we've gone from a situation where complaints were very much individually focused, individual transactions, to larger issues involving technologies that collect millions, if not billions, of bytes of data from individuals. So we've gone from looking at how an organization has perhaps collected somebody's license plate information from an individual or a license registration to situations where applications on your iPhone have collected improperly all kinds of information, in fact, to track people and so on. That's the way things have evolved over the last 20 years, and our legislation has shown itself, I think, to be very resilient to handle those things. So the Personal Information Protection Act, 20 years old now, it's served the province very well, but clearly changes are needed to keep up with the times. I think one would only look around to see that the technologies that have developed around us, from our computers to our cell phones and others, devices, have not just expanded our world in a very positive way, but they've also resulted in the collection of much, much more personal information about all of us. We need to make sure that the laws that we have in place reflect that. One of the issues that needs to be dealt with in British Columbia is mandatory breach reporting. That means that where an organization has your personal information, where it's either been hacked or it's been disclosed for reasons that it should not have been, that information is reported to our office, but more importantly, reported to you as a citizen, so that steps can be taken to make sure that harm is mitigated. It's also important to recognize that there are some bad actors out there in the world, and they harm everybody, including all the organizations that play fairly by the rules. And when those negative things happen, the regulator, that is to say our office, should have the power to properly sanction those violations of the law. That means proper administrative monetary penalties need to be put in place. That is now the case in Europe. It's now the case in Quebec. The federal government is looking at giving the Canadian Commissioner those powers. We need to be able to work in concert with all those authorities to make sure that there are proper penalties in place for those who decide to transgress the law. And so British Columbia needs to move in that regard, along with mandatory breach notification, and we would continue to encourage the government to go there.